Let's talk about Mrs. Charlotte Osei. The Flagstaff House issued a statement under the hand of the Chief of Staff, and it communicated that the President, in consultation with the Council of State, has appointed Mrs. Charlotte Osei of the National Commission for Civic Education, NCCE, to replace retired Chairman Dr. Kwejo Afarijan, who had steered the affairs of the Commission for about 20 good years. Mrs. Osei is a lawyer with considerable experience in public service management, institutional reform, and also expertise in corporate law, banking, insurance, project financing, and public-private partnerships. I'll start with that, with Honorable Yusuf Saini. What do you make of the choice?
Well, it's a good choice. It's a good choice because, one, it has brought the issue of the appointment of an electoral commissioner to rest.
Really?
Yes. The president has exercised his powers under Article 72 of the Constitution and has appointed Charlotte. Charlotte has shown clearly in previous lives that she has been a woman of substance. I mean, if you go back and look at what she did in Legon, she was the best female art student of the year in the hall that she lived. She won numerous prizes in Legon as well as the law school. She also won prizes in the school, in the LLM University in Queen's University in Canada. I mean, and clearly, even in public life as a solicitor, secretary or so at Commercial Bank and other places, she distinguished herself. She came into the NCC to help educate the people of Ghana on their civic responsibilities. She's done that commendably. I think that moving from the NCC to Electoral Commission is just a transition, because as one of the functions of the NCC is to educate people on how to vote, their rights and responsibilities during voting. And she's now going to take the responsibility. In the first instance, as NCC, she was an educator, and she embarked on educational activities of Ghanaians. And now she's going to be an abater to determine who has been validly elected president, because she becomes the sole returning officer in terms of presidential elections. So she's going to now determine who has been validly elected by the people of Ghana when we do go to elections.
Maybe confirm.
Oh, confirm, yes. Confirm by who has been validly elected, yes. And then not determine, okay, confirm, yes. But I want, yeah, confirm by the votes that have come in. And so clearly, I think that it's a challenge. I mean, and no one will pretend that being appointed as electoral commissioner and stepping into the shoes of Afarijan will be an easy job. Afarijan had in the past done it so well that he won the admiration of many people until the last election, when people started questioning his decisions. And so stepping in, even in Africa, Afarijan is widely respected as somebody who's pretended and shepherded our electoral commission and our democracy and founded it on solid grounds. Now a lady is going to step into her shoes, and so it's important that she lives up to expectation. That will be the challenge. Okay, now, I mean, chauvinism too might come in, because people are going to see her as a woman, and so she has to stand her grounds and show. But I have no doubt the Statue of Liberty in America is represented by a woman. I know she can be fair, she can be just, she can be strong, she can be resolute if she chooses to be. And I'm sure in this case she has no options. She has to be fair and determine and administer the Electoral Commission in ways that will win the respect of not only all the political parties in Ghana, but also the international community. And she will do that. Again, it shows that Plato once said that, I mean, you can't keep one half of the population of your people subjugated and hope to develop. I mean, the women are part of the population of this country, and they ought to be playing meaningful roles in determining how we chart the development path of this country. Under President Mills, we had two important women occupying two important government institutions in this country, the Parliament and the Chief Justice, the Judiciary. Today, we are going to have two important women determine the destiny of Ghanaians in future, I mean, in terms of if there come to be an election petition, the woman who is pretending the Supreme Court, or the person who is pretending the Supreme Court will be a woman. The person who will supervise the elections will also be a woman. So we have now put our whole destiny in the hands of women.
The government's lawyer is also a woman.
The government's lawyer is also a woman. Yes. So clearly we are tapping on the potential.
And the first lady.
Okay.
It's also a woman. Very important position.
Well, you see, the interjection reminds me of an accident happening, and they're reporting that it was a fatal accident, and another accident whether anyone died at all. Because the first lady can only be a woman.
Well, I said it for a reason.
Gabi, we'll discuss some fallouts or other issues that have come up as far as this is concerned. But Gabi, there are those who have already started. He began to point out already people trying to measure her under Afari-Gyan, you know, Afari-Gyan's character, you know, demeanor, posture, the stubborn, quote-unquote, sort of posture in the way he handled things. He says that she has no option but to be firm and fair. Is it fair to look at her, you know, in that mirror?
I think it is fair to expect nothing less than professionalism, impartiality, and a strong level of objectivity to fulfilling the objectives of the commission. To me, that's really what it's all about. And you know, the difference between the appointment of Afari-Gyan and her appointment is that by the time Afari-Gyan was appointed, first of all, I think as Deputy Commissioner to INEC, and then a year after, we didn't have political parties per se, or the political parties were just about beginning. Okay? But this time we have political parties. And I think that it was for one of the reasons that the Christian Council, the Catholic bishops, political parties, and civil society were all asking for greater sense of transparency. They wanted to see it manifest. There's transparency, there's consultancy, you know, because there's always the natural proclivity of a president who has a partisan interest in the process to choose someone that he is comfortable with. And the description, definition, and contextual understanding of that comfortability level may be deemed someone who may be affiliated with the party. You know, so to me, those are the things. I mean, I've known Charlotte for a long time, and I don't think anyone can tell me that she's not affiliated with the NDC. I don't think anyone can tell me that. Let me make my point.
Okay.
Let me make my point.
I don't know of that.
You don't know.
I'm learning about that. So
You don't know. But I'm saying that. I'm saying that as a fact. But you know.
Affiliated in what sense?
In what sense?
No, please. Let me make my point, and let her come and say if I'm wrong.
No, she's not here. You see, that's the problem.
No, she doesn't have to be here. She's listening.
And you're saying that's a fact.
She can always respond.
That you saw
No,
you can tell us that you saw her membership card.
My point.
I want to hear the evidence.
I'm saying that I know that as a fact, and she knows that as a fact. Okay, and I don't. But you see, to me,
I ask you to properly characterize the affiliation.
The affiliation is in terms of her political leanings. There's absolutely no two ways about it.
And how do you come to that conclusion?
I come to that conclusion because I know her, and that's all I'm saying.
I don't think you have said anything.
No.
I'm saying, you can proceed.
But I'm saying because I know her. But to me, because like I said, first of all, let's accept that the president has to have a strong sense of comfortability with the person because as between you and as we were saying here, we don't even know the process of the appointment. It wasn't transparent. A lot of us were asking for the consultation process to be broadened. That never happened. If it happened, we didn't see it, we didn't feel it. I had all the political parties, their chairpersons, including the chairperson of the NDC, the chairperson of the MPP, chairperson of, I believe, CPP and PNC, met under the auspices of the IEA and demanded greater consultation in this. You know, but none of that, for some reason, the president ignored all that.
They made demands within the constitution or outside of the constitution.
You know, look, what is not unconstitutional is not outside of the constitution. It is not unconstitutional to ask for broader consultation. So it is within the constitution. What you can say is that the president is under no obligation, and the Council of States are under no specific obligation under the Constitution to consult. You can make that argument, but don't say it is not in the Constitution, because you know the Constitution is that we should deepen our democracy.
I thought that the situations where we compromise the terms, clear terms of the Constitution all over the world is when following those clear terms will occasion a certain, you know, violence, will occasion a certain disturbance. But if it will not, why do you compromise the terms of the Constitution when they are followed to the letter?
You are not compromising. You know, if you only compromise the terms of the Constitution when you say that it is not the Council of State that should advise, but some other body should advise. It is not the president that should appoint, but some other body should appoint. As we have grown to accept that the EC has independence, and the independence is jealously guarded by the Constitution, is entrenched. Yet the EC works within some IPAC form of arrangement. Okay, the reforms that took place, there was a committee that was set of political parties and civil society. So it's within this culture, because when you look at all constitutions, especially just even in Africa here, ours is one of the most extreme in terms of empowering the president and his advisors solely, just exclusively, the two of them, the president and his advisors, in the appointment of an important position. And bear in mind, this lady is probably, I think, about 45 or so.
49.
49? Yeah. 49. So we know for sure that at least she's there for 4 elections. Okay?
21 years or so.
She's there for what? 4 or 5 elections. That's what, you know. So for such an appointment, I don't want to get into whether she can do the job professionally or not. But I'm saying that the process, that is why people were asking. And when you are asking for greater transparency and greater consultation, you are not saying that the president or the Council of State should do anything unconstitutional. So that aside, but if you allowed me to conclude on my earlier point, what did we see on Thursday? In the US, Chief Justice Roberts, conservative as they come.
Yeah.
What happened with him on the Obamacare?
He voted to uphold the
who
Obamacare.
saved
And that's the second time.
The second time, of course. So I would not want to judge her or prejudge her on her affiliation with the NDC.
On her alleged affiliation.
It's not alleged. I'm saying that for a fact.
You are alleging
I'm
it.
not alleging. I'm saying that I know. I'm saying that. So please, don't put words in my mouth. I'm saying that she's affiliated with the NDC.
Okay.
But I'm saying that I'm not going to prejudge what she brings on board, how she conducts herself at the EC based on her history with the NDC. I'm going to, I think we should all judge her based on how she operates within the remit of professionalism, objectivity, impartiality, and also been progressive in changing the culture of the EC. There are issues with the culture of the EC itself. There are issues before her in terms of reforms. How committed is she to it? And you know, I always felt, and I'm sure some of you will agree with me, that in approaching a person like Afrajan, who had been there for what, 20 years or so?
Yes.
Okay, and saying
and the
that
mention of years again reminds me, she's 42. 42.
She's 42.
She's supposed to be 42.
I expect she's more than. No, she has to be more than
49. She's supposed to be 42.
42 is not possible.
She has to be more than 42.
Why is it not possible?
No,
she has to be more than 42.
You are in school with her?
No.
I expect
she was your senior. Okay, by far. Okay.
Yeah. But I expect she's not yet 50. That I'm pretty certain of. Okay. But you know, Afrajan was there, chairperson for a long time. And his attitude towards criticism of how elections were held, instinctively we were bound to be defensive. Okay? I mean, if you issues about the bloated register and all that, instinctively we can expect him to be defensive, because when you are saying that this is wrong, that is wrong, you are criticizing his job. You know, she comes with no such baggage. So I think she should have an open mind, more open than we saw in the past. And look at the evidence, look at the facts. You know, if you have situations where a place like Northtown in 2008, the voters registered was 74,000, and by 2012, it has shot up to 127,000, a 71.5% increase. Clearly, you know, I'm not too sure that whether they discovered oil in Southtown, so Northtown, so within the 4 years, everybody moved there. Nothing extraordinary had happened to if like occasion such a huge jump in numbers, and there's so many of them. You know, so I think if such evidence is before you for a country with a median age of 20.8, and you have 55, 56% of that population captured on your register, and there are clear issues of such anomalies, I think she should have a different approach to what her predecessor had, and look at all these matters, because we are looking for a situation where the stability, the peace, and growth of our democracy can be, if you like, assured under her tenure. So, right. So I would not prejudge her, but I think it's a wonderful opportunity for her to show what she can do. And she's a lawyer, and I'm sure that can help her to also look at things perhaps differently. I wish her the best.
We'll take a break here. When we return, we'll look at more issues arising out of her appointment, and Gabby started one of them already, the demands that are being made on her about the need to change the register. She should be committed to all of those matters. We'll look at that and ask also the questions about what has happened, whether it is prudent or not, moving her, so to speak, from the NCCE to the Electoral Commission. Is this going to be some bad precedent that someone mischievously can take advantage of? You don't want someone who is in one such position, you simply give them another job. By that, you have removed them from that office. We'll be right back. I'd like to hear Kweku on this before. I don't know, first of all, what your assessment of Mrs. Charlotte Osei is. Gabby, you know, makes reference to her association. We need further and better particulars to be able to establish that positively, but he ends on a note that, you know, he knows her to the point that she's capable.
Well, I think in the Constitution, I've forgotten momentarily the particular provision. If you hold an office of a party, you cannot be a member of the NCCE. That's the constitutional thing. But if you are politically affiliated, as if you have a certain political orientation or ideological orientation, that's not a bar to being appointed to the thing. And in any case, bottom line, if you get in there, you have a certain security of tenure. So I think that enables you to become, you know, an independent-minded person. You
will appoint them. You are unable to remove them.
Fantastic.
Absolutely.
Fantastic. Yeah. And that's what struck me when you made an earlier point about reassignment and the fact that it could come with some mischief. I thought that perhaps may be an over-exaggeration in terms of the concern. Because, you see, we are not talking here removal. The Constitution has specific provisions. If you are removing those people who we appoint to the independent commissions, it's like you are dealing, if it's the chairman or the deputy chairman, you use the procedures that are used for the Court of Appeal judge, as well as the High Court judge. So it is stringent and it's not easy. Reassignment, as you put it, in this case, I'm not too sure if that's an appropriate description. You understand?
I'm not too sure if I use that.
It's a new job offer.
Yes,
it's a job offer.
You did.
That's how you should see it. It's a job offer.
Yes, and obviously it would have come with her consent. There would have been discussions with her. she would have felt ready to take that appointment. Otherwise, if it was removal, then she could challenge that whole exercise.
I said appointment by removal. So I'll give you a new job and you accept it.
That's even the worst description. That's the worst description if you compare it to reassignment.
Okay.
But I think it's an interesting area that people should look at. But I think we have enough cure for that if there's any mischief because of how they have their security of tenure and the constitutional provisions for their removal. That's my own view.
Right.
You know, if it's a strong personality and you are giving me a reassignment or a reappointment and I don't want it, once I have security of tenure, I can stick to it. You push, we go to the appropriate forum to adjudicate on the issue. So I think we have enough sufficient cure. You know, now the lady herself, I don't know her personally, but I've admired her from a distance. Very beautiful lady, and I'm told she has fine brains in terms of the legal.
So your admiration was not based on her.
Gabby.
No, I'm just.
Gabby,
I'm
hold
just
it, hold
looking
it,
for
Gabby, hold it,
clarity.
hold it. Yeah, hold it.
Clarity.
Yeah, it's true. I admire her, you know, and indeed I like the idea of women also being put in very important positions. I like it. It's a philosophy I've held for a long time. Indeed, it's interesting. I'm not sure if the ladies are still there. Mr. President Kufuor appointed 3 women at one go to the EC. 2004.
There are 4 women. There are now 5. Now 5 women, 2 men.
Yes, so it's quite interesting that when it comes to that particular agency of state, or if you like, the constitutional creature, we have actually empowered it using the female domination. Quite an interesting thing. I find it very significant. But whatever it is, that is not where my focus is now. To be honest with you, I was a bit intrigued that this appointment came ahead of the Supreme Court case. There's a case at the Supreme Court.
Yes, filed by Richard Sky of City.
Yes, that is my only problem. And if we are not careful, it could easily drag her appointment and the personality itself into the muddy waters of partisan political calculations. I was thinking, what's the rush? Why couldn't we exercise a little bit more patience, restraint, and allow the process to proceed? You see, because we have a gray area, which we've been debating all along, as to the procedures and processes that must be adopted to appoint a EC commissioner or deputy commissioner.
How did it become a gray area?
Because there hadn't been too much transparency since we began. At least let's begin from the Constitution.
So we inflict ourselves with a debate and then we go to the Supreme Court. Is that not what it is?
Yeah, but where is the alternative? Do we have the luxury of an alternative if we want to resolve a constitutional controversy? We have only one forum, and you know that better than I do. So yes, we've inflicted ourselves with that over the period. Okay, I've tried, I've been searching. I've got some few Council of State documentation and things, and I haven't found the actual answer I'm looking for. I thought through this process at the Supreme Court level, even if they couldn't compel production of minutes and documentation, records of Council of State, that could help us see what happened with previous appointments, then they would, looking at the law, then would have given us a determination. Look, I'm a street-minded legal brain, if you like, but if you have somebody like Professor VCRAC Crab, I'm sure you remember what he said. I know your position is slightly different. I mean, Samson. But if you remember, this is what he said, and I want to quote it. When the Constitution uses such language acting in accordance with the advice of the Council of State, in essence, it is the Council of State which is making the appointment, because the expression shall act in accordance is mandatory, and therefore in law, at least the President is bound by the decision of the Council of State. The question is, what role did the Council of State play? Did they present some list that the President chose from? I see, because that's what happens at the Supreme Court level, the superior justice. Am I right? The Judicial Council and all those bodies, you send some list. That then puts a restriction as to what the President can do, and then he picks from there. You are respecting the spirit the letter and the spirit of this thing. Now, my view is that this appointment the appointee may be good, may be competent, may be very professional, would end up exercising a very high level of integrity and independence, but all this would have been better if it had come after the determination by the Supreme Court. After all, we all knew, I think we had dropped the hints even on this program before, that she was the choice of the presidency. Okay? I knew of another alternative name that the Council of State appeared to be interested in, okay, which was more or less one of the ladies on the EC already.
Georgina.
Okay?
Yes.
So I knew about this. So the question is, did the Council of State eventually compromise and said, okay, we go along with you? If that happened, then perhaps they were still meeting the constitutional requirement. Because the Council of State would have ended up agreeing that, okay, we've advised you now, take this. My view really is that we should have waited. The President should have waited for the Supreme Court to determine this issue before making that appointment. The appointment may be good.
Yeah, maybe you should take it on from that legal perspective. You've heard out there whether there is contempt. Is it real? Your potential contempt, contemptuous act that the President has been engaged in, and that this could be such a hefty slap on judicial independence, or it's just a fuss that we are all about. But, I mean, respectfully, as far as the process is concerned, the mechanism of the selection is concerned, I share the view as Kuku just expressed.
Yes.
Yeah.
Well, before I go to that, when you read the notice from the presidency, something struck me, that the President, in consultation with the Council of State, is that what the Constitution says?
Is that what the text says?
That is
what I heard.
That would be interesting. Let's read it.
What I read is not exactly the text.
Okay.
It's not exactly.
Because
it's a report on the text.
I've been looking for a copy, certified copy.
Okay, I'm looking for it at the Flagstaff House page. So you go ahead.
Okay,
go ahead.
But at least that is what I heard. So if
you go ahead, we can abandon that and move on.
Well, no, because I'm linking it to what Kuku said, which is excellent. But you see, there has been a controversy over these matters. For example, when the case is pending before the court and there is no order of injunction or an application of injunction pending, if you believe that the very thing for which you have gone to court to obtain judgment or a determination can be removed or interfered with to the extent that by the time you get your judgment, it will be nugatory. Then you file that.
Okay, the statement from the presidency was that the President, John Dramani Mahama, has, in accordance with Article 72 of the 1992 Constitution, appointed Mrs. Charlotte Osei as chairperson of the Electoral Commission.
Well, that at least. That
so the advice is captured there.
The
advice is implied in that.
In accordance with Article 72.
And what does 72 say?
It is
Advice.
presumed
Advice.
That's the point.
It is presumed, but the other one that was read, I think then is problematic.
But what will be interesting, if I may just add, is the defense that the AG filed to this case, because that could be presumed to be how the President interpreted his.
Yeah, but they filed a defense, ready to litigate.
They have.
Of course, the AG is the chief legal advisor of the President.
Yeah.
And I believe that the President would have consulted the AG to seek her own opinion. So, in the absence of an injunction, in the recent case that the EC was brought against the EC in the conduct of the district, the local government election, I was there. The court.
The Ayi Mensah case.
Yes, the court. The members, if I remember, and I can use the word upset, or were not happy with the fact that whilst the case was pending before the highest court of the land, even in absence of injunction, the EC had not in fact done the very thing for which the case was pending. But they were taking steps, all right, to do it. When you compare it to this, in this case, it appears that what has been done may have the effect of making the case before the court a moot one. And for me, I think those who say that it amounts to overreaching the court, which is not something that the court looks at lightly, may be right in saying so. Because it turns on, there is a disagreement, there is a controversy, and it's even exhibited in the statement of case filed by both the plaintiff and the Attorney General.
I asked the question, a controversy at what level? Where did the controversy come about?
Well, the fact that it is even pending before the Supreme Court, that controversy is pending before the Supreme Court. One person, a citizen of Ghana, says that this is my understanding of this provision of the Constitution. And the chief legal advisor of the state, the #1 lawyer, also disagrees with that person. The only place that our laws stipulate you can resolve this particular matter is before the Supreme Court. So it is not...
Do we know the content of what the state has filed as far as this matter is concerned? Because they went to court the first time and they sought an adjournment, so extension of time, so that they could file their processes.
Well,
it's due for the 4th of July, is it?
I think 14th.
Okay, 14th. Yeah.
You see,
But they have filed.
Yes,
They said that's fine, though, but I haven't seen.
So since we have not seen, you may not be sure that they actually are defending it.
But I listened to the lawyer on the other, and I think he would have represented what was right. He said that he has even found a reply to what the AG found, which means that the AG has raised some arguments which are in opposition and raises a controversy, so they have filed even a reply to it. That clearly indicates that there is a serious controversy turning on the meaning or the construction or the interpretation to be put on this whole Article 70 Clause 2 provision. And so when it is pending before the Supreme Court, I think the right thing to do, and I know there are quite a number of constitutional cases there. This is one of the swiftest I have seen because of perhaps the exigencies and the urgent nature of it.
In the Abu Ramadan case, it was the same.
Yeah. Yes.
The Abu Ramadan case where they sought to stop the EC from using the NHIS cards as one of the documents for registration. Whilst the case was pending, the EC's adverts were going on. And the Supreme Court gave a warning and asked that they withdraw the adverts. They withdrew them.
They repeated it in the second case.
But is there not a difference between the cases you have cited and this particular one? This particular one is not to inquire into what has been done. Those cases were to inquire into what has been done, which they said had been done wrong.
No, but in the latter EC case, they had not done anything.
They had.
No, but they were taking steps.
They had promulgated an instrument, and their argument was that that instrument was premature. So they went to challenge that instrument. In this particular case, the applicant in court is not saying the president has done something wrong, and that's what I'm coming to challenge, or that the Council of State has done something wrong, and that's what I'm coming to challenge. So what is there to injunct? Well,
seriously, I don't really see the real difference between these two situations. The fact of the matter is that there is a matter pending before court. An issue has been raised on whether or not the president is the one that has the ultimate responsibility to appoint EC board, and whether he is bound by or to follow the advice of the Council of State. This CRC Crab was one of the important persons who were part of how this constitutional committee of experts and the consultative assembly came about. In fact, there was one case under directive principles of state policy where they had voted in favor of the fact that the directive principles of state policy should be justiciable. But the final report said something else. It took people like him to correct that he was there when they voted in favor of justiciability. So when he speaks to it, I think he's not only looking at the text as we are doing, but he had personal experience and in view of
Okay.
Well, what is done in
I
the
understand
past?
we are having a few difficulties. We'll come back, and when we return quickly, I'd like to hear. I almost said her name.
Honorable.
Sorry, Honorable Ines Afuseni, quickly on this matter, and I am asking the question, straight and simple. The President and the Council of State are about to do a job. They have not done the job yet, and I go to court. Am I questioning that job? Are we saying we know for a fact that the President did something or was about to do something wrong? We'll be right back.
Well, interesting.
But it may be based on previous...
I'll hear from Ines Afuseni before I share with you some of the messages that all of you have been sending around. So, simply put, this is the way I look at my questioning.
Okay.
And it may carry with it an opinion.
Okay.
I'm saying, just how does a suit before the facts, a suit that is filed before the facts or before the event, a suit which is not an inquiry of the facts of a process, how does it affect that process directly?
Well, let me answer by saying that the Supreme Court has repeatedly said that they don't have speculative jurisdiction. Repeatedly. And so, if you are coming to them for your case to be determined, you must show a cause. You might, in fact, if you are coming for them to determine whether or not an act has, or an omission has infringed constitutional provisions, you must demonstrate that. They can clothe themselves with speculative jurisdiction.
Okay, now be careful, because you seem to be trashing the substantive suit.
No,
in court.
no, because you said a suit. So a suit, whether a suit can operate to withhold. I'm just these are general legal principles that I'm espousing. I'm not dealing with the necessity of the case or the merits of the case. But let me say that I had compromised the Constitution on 2 occasions. We can't compromise the Constitution. We can only interpret the Constitution under a doctrine of necessity. But immediately the Constitution itself is a principle. Immediately you compromise the principle, you lose the principle. So you have to interpret the principle in such a way as to give meaning to what the framers of the Constitution envisaged. So no, indeed, the constitutional provision, Article 72, is clear. The President acts on the advice of the Council of State, in appointing the Electoral Commission.
But it's a fact also that constitutions have been compromised in the when there is potential crisis or crisis.
Not compromised. The constitutions have been interpreted. That's where the golden rule comes in.
Because it's a living
document. So it has to be interpreted to give meaning and effect to the situation that exists.
Okay, now move on to this issue about the fact that the decision is a slap on judicial independence, so to speak.
No, it is not. It is not. The Supreme Court, you remember Richard the Williams case in the UK? He overthrew the establishment, held himself out as Prime Minister. After so many years, the Supreme Court, the courts in Britain, the House of Lords said that he was not. Simple, he was not. So the Supreme Court can always make a pronouncement, and then we'll take it from there. Okay? Now, the Constitution lays out elaborate procedure for the appointment of persons under the Constitution. The Constitution does not say that those procedures should be published. It's not like the discretionary powers vested in the President under Article 296 that compels publication or obliges the President to publish how he's going to go about it. This is one part of the governance regime in this country. Now, but the Constitution is a living document. If you want to amend and bring greater transparency, there are ways to go about it. There are ways to go about it. When Roberts was being appointed in the United States of America, then George Bush was not under obligation to publish how he had gone about selecting him. The procedure required that after selecting him, he presents him to Congress. Okay? In accordance with the Constitution of the United States of America. Now, you see, and I like this idea. I mean, in constitutional law classes anywhere, I thought they will tell you that one way to secure the independence of such constitutional bodies and persons is the tenure of office. Insulation against manipulation, because he cannot be removed. And that is why Afarijan, when in 1992, Afarijan was said to be an NDC member. In 1992. And that was why Rawlings appointed him.
Oh no.
Yes, 1992. Yes.
I don't remember.
Probably you were in London.
No, I was here for that. I don't remember that.
You would have heard it.
It wasn't a major concern.
In fact, it was a major concern. Afarijan was a major concern.
But you see, frankly, just a second. I think it's not so much about what the Constitution says, as it is about the person who is to perform the function.
Yeah, that's true.
So even if your appointment is not insulated by the fact that it should be permanent, if you view your loyalty to the Constitution and the people of Ghana, you shouldn't worry about whether or not another person.
What happens to the suit pending now? What happens to it?
Well,
I think the court will pronounce on it. The court will pronounce on it.
I think that, in my view, and without prejudice, they can go to court and bring this matter before the judges and let them determine. Maybe
the judges would have taken judicial notice already. They
no.
That the EC chairman has been appointed.
They are not influenced by what has happened outside of the court.
Yes.
They ought not to be influenced.
Yeah.
And then this should not be a matter that I believe they should justifiably take judicial notice of, because it has a consequence. At least in the view of those who believe that this should have waited. And so I think...
Was the suit against this appointment?
The suit was not, as what I've read, in view because there was no such appointment at the time. All right? The person has gone to court for an interpretation of a constitutional provision. And one of the grounds is, as in Article 2, whether there is an act or omission which is inconsistent with or in contravention of a provision of the Constitution. And that is what I believe is before the court. But you see, one last point. You see, there is also the angle, which is still relevant in law, that where the law imposes or assigns a statutory duty on a person, the courts are usually slow. Somebody even said that we usually not restrain the person from performing, especially if there is a necessity for it. So that may also be some consideration. Is there a necessity?
But finally, a quick one from you. A quick one from you. You don't subscribe to the positions that have been shared here, that it would have been prudent for the government to wait.
That will be a dangerous precedent. A very dangerous precedent for our democracy.
There's a potential that this suit would have been determined by, in how many days? 16 days.
That will be a very dangerous precedent. That you can allow people to go to court to prevent the performance of a duty by simply relying on their own personal idiosyncrasies. That would be difficult. That would throw our democracy into a confusion.
This is not a personal idiosyncrasy. It's been a national debate.
No. Why? The Constitution says the president must do it this way. His view, his belief, his thinking, influenced by some other persons, is that in doing it that way. Motivated.
I think he's intelligent enough to
Continue. Just continue.
Alexander Markins. I'm not saying that.
Yeah, but he's not
even the party.
Richard Sky.
He's a lawyer.
Okay. Now somebody interprets these provisions the way he understands it. Yeah. That's where the idiosyncrasy comes in. I'm not saying that. That's
why is the Supreme Court
No. the Supreme
But
Court
the
has
Supreme
even
Court
said
disagrees on
that's
even shall and may.
I
No, the
thought
Supreme
he's
Court-
saying that
no,
we
the Supreme Court
we
says-
all personally interpret the Constitution
the
even
way
before we get
go-
there.
get
Yes,
there.
but that's why the
That's
Supreme
our
Court
own-
is there
Correct.
as a
That's
final
our own
arbiter.
We must
idiosyncrasy.
disagree.
And so when you go there, when
Okay,
somebody
okay,
does that,
all right,
when
yeah.
somebody does that, and then says, okay, now, in fact, we only had one, even though it was good, where the whole local government administration was thrown into confusion. Now, that is within the context where we can manage. But even that occasion has a lot of loss. Now, what I'm saying is that let's not open the floodgates to persons who will go to court and prevent the performance of a duty, because that is a dangerous precedent.
Okay.
I think something.
Yes, Gabi.
I'm not too sure we have to stretch it that far. I mean, I see this case squarely within the remit of the Creator-Met principle, in a sense that you fear something would happen.
Yeah.
And I think that's how we should see this. And it's based on some level of reasonableness of what had happened in the past. Okay, so it is not to prevent the president.
Okay, so
from
get clear on this.
Creator-Met
Practically, what are you looking at? That,
The
for
Creator-Met principle
example,
doesn't
the
apply
appointing
in
authority.
No,
the appointing
please.
authority.
Yeah.
Is it that the appointing authority was afraid of something that will happen?
No, my point is, there's you the person who is in court.
Okay,
Okay, you are in court because you fear the wrongful act.
might happen.
It's threatened, and you are going before it even starts. And this is how, as far as I'm concerned, this is how the suit should be interpreted. So you are going for an interpretation that will stop a wrongful act from happening. And you are looking at, I mean, let's not pretend.
That's what he says.
but it's
The
not
Supreme
just-
Court does not deal with speculative.
No,
It doesn't
but I'm
understand.
saying, I'm saying the principle
provision and Article
of
33.
Creator-Met injunction and
Yeah,
all of
it's
that.
an
The Supreme Court, they act under that. So how can you say that they
In
don't deal?
constitutional
What is
matters.
speculative? What
By
is
constitutional
what is
matter, Article
speculative?
33
Sorry,
says
sorry,
if-
sorry,
Yeah, please,
sorry.
go on.
Let's
No,
move on.
just if you believe that
Yeah,
your
absolutely.
right is likely to be contravened.
rights. Human
Human rights.
No, he
Human
said-
rights.
I'm
This
not-
is human rights.
He said
33.
not,
But that's the
not
High
in
Court.
relation to the Constitution.
This is human right.
interpretation of the
The human
Constitution.
rights is part of the Constitution.
But that's a high court matter.
But this is a different
No, he
issue.
said that.
No,
not in relation to the constitutional matters.
interpretation of the Constitution.
Okay, let's not get into that.
Sometimes
Because the Constitution says that
sorry,
act
my
on-
problem with this
sorry.
program is it gets too legal sometimes. If you have a host as a lawyer, that's what happens. But I think really to me this may call for some level of amendment of the rate itself. I don't know, but that's the impression I get. Because I mean, first of all, if the Supreme Court, in even making a judgment, will look at the arguments made by the Attorney General. Because in the Attorney General's, in her defense, she will state the President's interpretation of his powers.
Right, 72.
Absolutely. Or
So
how-
supposing the Attorney General has gone to court now,
Yes.
and we haven't seen his
But
brief
she-
yet.
but she has
Supposing she's filed,
Yeah.
and what she's filed
Yeah.
is saying that, my lords,
Yeah.
what the applicant is asking for is exactly what the President is going to abide by.
But it means there's no case.
It means there's no case.
There's no case.
So do you find that it's speculative
no, but
in that
that's
sense?
if the Supreme Court agrees with what both the applicant and the AG agree with.
But that's
All right.
on the day of determination.
No,
All right.
yeah, absolutely. But I'm saying that so for now, if let's say I haven't seen the AG's defense, but the AG's defense is that the President can choose to refuse to accept the advice of the Council of State, as Kweku Baku just hinted, it's supposed to have happened.
Okay. Thank you.
So
Thank
and the
you.
Supreme Court.
Thank
No,
you.
please.
Thank you. Thank
I'm
you. We
stating-
need to move on. We have
I'm
two
stating
other
a
big
point.
issues
Let me
to
finish
deal
the point
with.
I'm making.
Yes.
So that is what the AG is saying, and the Supreme Court thinks differently. Can it then not presume that this is how the appointment happened
Has been done.
and is wrong?
Okay.
You know, so it's a major issue that I think, but we leave it to the Supreme Court too.
Yeah.
Okay.
I was just
Thank
going to
you.
read Article 2(1)(b) to you, so that probably we'll put the issue of Creator-Met actions in relation to the interpretation of the Constitution into perspective. It says that any person who alleges that any act or omission of any person, so there must be an act or there must be a failure to act.
All right, thank you. Now, shall we move on? We go find out what is happening in Agbogloshi and the demonstrations that have followed. But let's pick some of your messages. Musa Abatar in Kumasi says, the appointment of Mrs. Charlotte Osei is clear example of
Can you stop your phone from
action
vibrating?
In practice,
Mr.
not
Minister.
tokenism. My piece of advice to the NPP is that they should concentrate in reviving and educating their polling agents rather than attacking the integrity and hard-won reputation of the new EC boss.
But who has attacked?
Nobody has done that.
So
Nobody has
who is
attacked her. Elections are won on the ground, whatever. And then Simon in Wale Wale says that once Black Rasta has rendered an apology that brings to a finality the matter, Parliament must focus on their mandate in resolving the many problems confronting us as a nation. Ibrahim Koppa in Tamale says the Jamefe Commission's report was a clear opportunity for the ruling NDC government to redeem its image on the corruption albatross hanging its neck for a very long period of time. Unfortunately, however, the white paper issued is suffering an incurable selective amnesia. Okay, you're interested in just bundling the words together, which further deepens the corruption perception about the government. Kofi Atta in Cambridge says, the mere fact that there was a suit before the the Supreme Court for interpretation of Article 72 did not bar the President from appointing the head of the EC, unless a specific relief to that effect was sought from and granted by the Supreme Court. Okay, so moreover, Article 72 is not suspended because its interpretation is being sought from the Supreme Court. Mustafa Alima Zanga in says that I find it difficult to understand the speed with which Parliament used to protect its integrity. However, Parliament falls short in using similar zeal in protecting the nation from our corrupt politicians. Spike in Ohio says that the Jamefe Commission was a waste of the taxpayers' money. The reports were scanty and inconclusive. Ata Imoro in Wellency says that the appointment of Mrs. Okay, I think I've read this already. Thank you very much for your messages, and you sent these ones earlier. In the course of the show, I'll read the ones that you've just sent as well.